Raj, you're representing the appellee this morning?
I do, Your Honor.
Okay. Great. Mr. Shurkin, you may proceed when you're ready, and I'll keep your time.
Thank you. If it pleases the court. This matter initiated back in January of 2014 when an 8-count indictment was returned against then Judge Tracy Hunter. 4 days later, an additional indictment was rendered or returned on January the 14th, which only contained 1 count. And the matter proceeded to trial in October of 2014. Following the trial, the jury was able to render a verdict on 1 count. It was a 4th-degree felony that they convicted her of, and there was a hung jury on the other 7 counts. While the matter was on appeal, a 3rd indictment was returned on 3/12 of 2015, which was a 1-count indictment. The conviction count, count 6, which was the unlawful something involved with a public employee, went on appeal, and during the course of the appeal, the sentence was stayed, and it was fine. And the state had indicated that they were going to go forward with a retrial on the 7 counts, and I think the unlawful use of a credit card indictment, which had been returned in March of 2015. And the matter was set to go forward on January the 19th of 2016. On 3 days prior to that, the Court of Appeals affirmed the conviction of count 6, and the case was scheduled, and we were all prepared to go to trial on the 16th. That morning, the state came forward and requested the court to dismiss all the remaining counts of the indictment, the 7 counts which were where they were hung, and the consolidated count, which had been consolidated from the January 14th indictment in 2014. And in addition, the March 5th, 2015 indictment was also dismissed. The matter pended a motion to certify the case to the Ohio Supreme Court on the conviction was denied. A petition for habeas under 28 USC 2254 had been filed in the U.S. District Court. Meantime, the District Court continued to stay of execution. Following the completion of the petition for habeas, the court denied the continuance of a stay bond, and actually Ms. Hunter commenced serving the sentence on count 6, which had been imposed in December.
So as we get to the cost issue here, Mr. Shurkin, you know, you're advocating for almost like a pro rata approach on the costs, and the argument makes some intuitive sense, but I just had a hard time seeing like what the statutory or case law support for that was.
I think that there is case law that says that, you know, the court does have discretion to modify under the statute 2947. Court A does give that power to the trial court to mitigate or to suspend or to waive all the court costs. And what occurred in this matter is that although I know it was requested that it be prorated, I believe that it can be on analysis. There could be a determination. And what I would hope this court would do would be to remand this matter back to the trial court. I believe that when the initial briefs were written with the motion to mitigate, that there was an anticipation that the matter would ultimately be set for oral argument and that there would be some response by the state. The state did not respond to the motion. The trial court did not set the matter for oral argument, so that there was no discussion. If you go through the cost set, you can see where almost $27,000 of transcripts were ordered by the court for the use of the prosecution. It wasn't a full transcript, ultimately was filed in the Court of Appeals on the initial appeal, which would have included everything in the trial. I think which was paid out of pocket already by the defendant for that appeal. She was required, she was not indigent, so she was required to pay for that. Somewhere along the line, following the conviction, the state started ordering parts of the docket, the transcript. They had ordered some, I believe, prior to closing argument. There was a series of transcripts that they ordered following the sentencing. And then,
are you saying that all the transcripts were already ordered and filed by virtue of the initial appeal?
Yeah, it's my understanding that with the initial appeal, there would have been a requirement of would have filed the complete transcript of the proceedings, because there were arguments that involved a lot of various issues which would have been contained within that transcript. And so these were all, and what happened is that the trial court just made a presumption saying that, well, you didn't show how the defendant didn't get any use of these transcripts that had been ordered by the court for the use of the prosecutor. Therefore, he said, you're not entitled to any discount or any lowering or mitigation of these transcript costs. And I think that since they did not respond to the motion, that was a presumption, I think, that was an abuse of discretion, because he should have taken it on the docket itself. It indicated that, how those transcripts were ordered and who they were ordered by and who was ordered to pay for them initially. So that's
doesn't the statute allow for any court-ordered transcripts, either ordered for the court or ordered for the prosecution, to be taxed as costs?
It can be no, not if I pay it out of my pocket. It wouldn't be, unless I ask the court to ultimately at the end ask it to be taxed as costs. Because I was the loser on that one count, then it would not have been initially taxed as cost, and it would have been, and at that point there was only on the one count. And but they had to hire and buy the entire transcript for the appeal process. And so now really there's a double cost to that. Now that it has been, after the conviction was sustained, the court then assumed that all this cost again should be taxed to the defendant. And that's what happened, and I think could be explained if there had been some argument that could have been, you could have gone item by item. There was, in addition to that, a bundle of witness fees that came out of what would have been the retrial, that ultimately the state at the last minute, the morning of trial, asked for dismissal of the charges. And so we get stuck with those costs as well. And the court just blanketly, didn't give any consideration to that fact in our request for mitigation of the court costs. And the defendant, Ms. Hunter, was put in a kind of catch-22. In order to get early termination after she served her community, her jail sentence, she still had 1 year of community control. And if she requested early termination of that community control, it became almost conditioned upon, you got to pay the court costs. And so she was in that dilemma as to, then I'm really.
So when you were before the trial judge and in disputing the cost, did you make the point that she'd already paid for all these transcripts?
There was no hearing for it, and it wasn't in the briefs. I did not file the motion to mitigate. It was done by now Judge Jennifer Branch.
Right.
It filed.
And the issues on the witnesses, that wasn't in the briefing either, right?
Pardon?
Your argument about the witness fees.
She said and other court costs in the motion that she filed in the trial court. She talked about a general mitigation, talked about the transcript costs and other costs. And so I think that the other costs would have included a discussion about the witness fees. And it would have been, and I think she anticipated and believed that the state would have filed a response. And as I say, the docket indicates that almost $27,000 of transcripts were ordered by the court for the use of the prosecutor. And there's no showing that there was any benefit to the defendant from those costs. And it just seems on.
Is that required?
Pardon?
Is that required under the law, that the transcripts ordered by the court for the benefit of the prosecutor also have to benefit the defendant?
If you're going to charge it, I think it comes up into the discussion about whether it should be taxed to the defendant, because if it's exclusively used by the state, it seems that it would be inequitable to charge that cost to the defendant. it could become cost of a prosecution, but yet again, we only had a conviction on one count. In this case, it was a 4th-degree felony, and actually had just that count been charged and tried separately, there was maybe 4 or 5 witnesses that were involved with that particular count. And the trial would have not been 4 weeks, it would have been 3 or 4 days, and there would have been substantially less cost entirely with it.
But how do you get around or get me around the plain language of the statute that says that basically you tax per case, not per charge?
Well, but there are cases that do support, I think a couple of the cases that we cited in the brief are cases where they were singular. The one municipal court case, there was one count that was a minor misdemeanor, and there was another which was a 1st-degree misdemeanor, which allowed for a jury trial. He was acquitted of the charge that went to the jury. On the minor misdemeanor, the court found the individual guilty, and the court then, and that was an A and B type case, so it was under the same case number, and the court then only charged, the Court of Appeals said you only charge for the minor misdemeanor amount. You don't charge the jury fees or any of that. So I think that the statute is, I know it says, the winner, but I think the trial court has discretion in order to modify or to mitigate the cost, which would seem to be equitable in this particular situation because of the high cost of the transcript fees that went into this case that were ordered separately and apart from any appeal by the prosecution, and would have ultimately, I believe, were probably, there were some that were gotten, I believe, that they used for final argument. There were some that were ordered after the trial, and even though the appeal was pending, that they also ordered, but again, this case was going to be retried in 2016. Earlier settings on the case were in 2015, and in that calendar year that ultimately got continued, the transcripts were ordered that we believe were used by the prosecution in preparation for the retrials.
Mr. Serkin, if you'd like to reserve your 3 minutes, you're at your time.
Thank you, Your Honor.
Mr. Axelrod?
Thank you, Your Honor. May it please the court. I will attempt to address all of Mr. Serkin's arguments in due course. I do, however, want to start with what I perceive to be one of his primary arguments, which is that the court has discretion to reduce or modify court costs as it deems appropriate. In fact, the relevant statute 2743, as the court knows, commands that costs be included in a defendant's sentence. While the court has discretion to mitigate or modify costs under some circumstances, that it can't be arbitrary. Typically, it should be, as it was in this case, to mitigate or modify costs that shouldn't have been imposed in the first place. But to say that the court can mitigate or modify costs at its whim essentially guts the statute when the statute commands the court to impose costs.
Could the judge have just said, look, I know that I have the right to order this much in court costs, but it just doesn't seem fair in the grand scheme of everything because she was only convicted of one count. So I'm going to reduce it on a pro rata basis. I mean, could the judge have done that and not have abused his discretion?
I don't believe so, Your Honor. Let me take you to, I'm now getting out of order, which I try never to do, but I'm going to do it now. Let me take Your Honor, to the Supreme Court of Ohio's decision in Middleburg Heights versus Quinones. While I'm loath to read long quotations, this one is significant enough that I think it's dispositive of the case that I beg the court's indulgence in allowing me to read it. The Supreme Court first framed the issue. The court said, quote, we agreed to review only the issue of whether a municipal court has authority to assess court costs on a per charge basis, which is essentially what Mr. Serkin is asking this court to rule that the court can do, but the Supreme Court answered the question, no. The court said further, and I quote, Revised Code 2943A1 imposes a mandatory obligation on trial judges in all criminal cases to include in the sentence the costs of prosecution and render a judgment therefore. Now, I'm about to get to the issue of cost of count by count and why the court says that you can't do that. And I quote, the court said, "It does not specifically authorize the imposition of these costs for each offense committed. This interpretation conforms to the legislature's purpose in imposing court costs on a defendant convicted of a crime to finance the court system, not to punish the defendant additionally on each charge." The court said further in its opinion, trial judges are obligated to render a judgment for the costs of prosecution on a per case basis, although they may be made up of a number of charges or causes. So
well, let me ask you maybe a simpler question that picks up on what Mr. Serkin was arguing. I mean, he says that the full transcript was already in the record by virtue of the appeal. So if, I mean, A, do you agree with that? And B, if you do, why was the state continuing to order transcripts? I mean, that does sound like double counting.
Well, Your Honor, you have the unusual situation where neither of us tried the case. And frankly, I can't tell you off the top of my head. I'd have to go look to see whether in fact that they were in the record in their entirety before they were ordered later. I have no idea why, but that gets to an important issue, which is that the court can't tell why from the record either. We can only speculate. I mean, if I had to hazard a guess, some of the post-conviction expenses were, for instance, for the retrial. But I would only be hazarding a guess because Ms. Hunter did not ask for a hearing. The trial court specifically pointed out that she did not ask for a hearing, as would have been, in the court's words, the normal course of motion practice. And so she didn't make a record. She didn't submit.
But I mean, I guess part of the other difficulty here is you all didn't respond. So you didn't sketch out what your position was, which kind of leaves us, you know, looking at the trial court record, not having it fully developed on this issue.
Well, see, Your Honor, I disagree. I think that now we're really talking about kind of a permutation of the contemporaneous objection rule. The contemporaneous objection rule says essentially that you can't challenge on appeal. You can't make an argument on appeal challenging a trial court's ruling without giving the trial court an opportunity first to consider that argument and develop the record. That's the sort of thing in which the record needs to be developed. We trusted that Judge Dinkelacker would do exactly the right thing. We trusted that he could read the statute, that he would know the rules, that this was routine, and that he would do exactly what he did. And the record wouldn't be any more complete if we'd filed.
Yeah, but I mean, like if you take that to its logical extreme, the state never has to do anything. It can just trust the trial judge to do the right thing. I mean, the point is you all didn't explain in either a filing or at a hearing, which obviously didn't happen, what your position was. So we're kind of left not seeing the full expanse of what the arguments would be if they had been more fully developed.
Your Honor, I don't think what our position was mattered. All that matters is whether what the trial court did was right or wrong. And what the trial court did, according to the Ohio Supreme Court, was absolutely right.
Do you think it's right to tax costs incurred for transcripts that occurred after the sentencing?
Well, that's an argument that's never been raised before. It wasn't raised in the trial court. It wasn't raised in the appellant's primary brief. It wasn't raised in the appellant's reply brief.
It is in fact what happened, right? There are certain amounts. There's a certain amount of these costs that were incurred after sentencing.
There are a certain number of the costs that were incurred after sentencing.
Is that legal to tax those costs?
Well, you know, I've actually looked at that, and I can tell the court honestly that there is nothing, or I was able to find nothing either way regarding that. So we're left with the Supreme Court's command that you tax costs according to the case. Some of the post-conviction activities were activities of the defendant. And parenthetically, I apologize if you can hear a chime. I don't know how to turn it off. I'm not in my office. So I apologize to the court. My phone is.
I have a question, Mr. Axelrod.
Yes, sir.
What prosecution took place after the initial jury verdict?
There was a separate indictment, Your Honor. It was dismissed, so there was no trial.
All right. So indulge me for a minute here. Let's say I'm the county prosecutor and I indict John or Jane Doe for a charge, and it's pending for 6 months, and maybe there's a series of pretrials and whatever. And then at some point in time, I make the decision, you know what, I'm going to dismiss this for whatever reason. you know, can I make the defendant pay for the cost of that?
No. The reason you can't make the defendant pay for the cost of that is because 2943 commands that costs be imposed as part of a sentence. So the defendant has to have been convicted of something before costs can be imposed.
Okay, but the costs of prosecution seem to suggest that we want things for the cost of prosecution, right? At what point was she prosecuted after the jury verdict finding her guilty of the one count?
I think it's an integrated thing. I mean, the trial court doesn't lose jurisdiction over the case until the notice of appeal is filed. And while it's
I don't dispute any of that. I'm just asking what costs of prosecution conceivably were incurred after the jury verdict. The jury verdict found her guilty of one count. She was sentenced on that one count. I'm just trying to figure out what are the costs of prosecution related to anything beyond that jury verdict.
Well, she continued to attack the jury verdict, and the costs of prosecution were the costs of defending the jury's verdict and defending the court's rulings. So
Post-trial motions is what you're saying?
yeah, yes, ma'am. So there were many post-trial motions. There were all kinds of post-trial proceedings.
You need a transcript for a post-trial motion?
Well, Your Honor, again, there's no record for the court to review as to what those things were for and why those things were ordered.
I think
we can only speculate.
She asked for she said some jury misconduct. What would that, I mean, there was some claim about jury misconduct, wasn't there? She made that assertion.
There were all kinds of claims about the jury. There were all kinds of claims about the prosecution, about prosecutorial misconduct, about political vendettas. This was a very ugly case, Your Honor. And, I urge the court to take the cost statement and look at it carefully because.
And so on that point, one of the things that I noticed was there was a case number B140199 where there was costs for like $12,000 and change. And it's very difficult looking at CMS to determine whether that is separate or included in the $34,000 figure that is reflected in B140110. So I'm wondering if you can shed any light on that.
I haven't examined it specifically because frankly, the question never came up, but I believe the answer is yes. The cases were tried together. It was one trial. And I believe those costs are for the single trial. But
that one case was dismissed, right?
Well, this was confusing. There were actually 3 indictments. There were 2 indictments that were consolidated for trial, 1 multi-count indictment, 1 one-count indictment. There was a 3rd indictment that was never prosecuted. So the 2 that were tried together. And I concede that the cost statement only has 1 case number on it, but there is no other cost statement, and one can only reasonably conclude that all of the costs of the consolidated trial were included in the 20 plus, I think it's 23-page single-space cost statement.
Well, CMS shows costs incurred in the ultimately dismissed case as the $12,000.
The ultimately.
So is that separate from the $34,000 or part of the $34,000?
I believe it's separate. Again, the $34,000 has the primary case number of the case that was tried. But frankly, again, Your Honor, I haven't looked at this, and if the court would find it useful, I'd be happy to submit a post-argument brief explaining to the court precisely what costs were and were not included. So if that would shed further light on things, I'd be happy to provide that. There is one other important thing that Mr. Serkin said that I think requires correction, or rather further explanation. There are a series of cases that do try to divide costs by count. There are, by my count, 1, 2, 3, 4, 5, 6, 7 cases. Of the 7 cases, 5 were decided before Middleburg Heights, and so have absolutely no precedential weight because the Supreme Court had not ruled yet that you do it by case rather than by count. There were 2 that were decided after. One was a case called State versus Likens. And in Likens, the defendant pled guilty to 1 count of pandering to a minor, 2 counts were later dismissed. And the court imposed, and it was very specific about it, imposed costs of $124 per count. Now, first, I believe the case is wrong. It relies on another 4th District case called Weddington. Weddington, which was decided in 2015. So both of them are after Middleburg Heights. Weddington, however, does not cite Middleburg Heights and relies on all of the cases or a bunch of the cases that were decided before Middleburg Heights. So it's relying on precedent that has essentially been overturned. Furthermore, Likens didn't cite Middleburg Heights. So apparently the court was unaware of controlling precedent and failed to apply it. The other case, and further, it was a case where, when we talked about this a lot in our briefs, the costs were divisible because the court was very specific as to $124 per count in costs. You can't do that with this case. Again, I would urge the court to look at the cost statement and you'll see you can't divide it up neatly like that. So even if Likens were the law, Hunter would fail the test and wouldn't qualify for mitigation or reduction of costs under the test applied in Likens. Geary is a somewhat similar situation. Geary was decided by the 3rd District in 2019. Geary was a case where there were 2 alleged victims of sexual assault. The defendant was acquitted of assaulting one, convicted of assaulting the other. The court, however, assessed as costs the costs of the acquitted victim's guardian ad litem and court-appointed attorney. So the court allocated those costs, but they were allocated for costs that were exclusively incurred in connection with the acquitted costs. They were clearly divisible in a way that the costs in this case are not divisible. So I believe that Geary, which also doesn't cite Middleburg Heights, by the way, I think the court in Geary, like the court in Likens, was unaware of controlling Supreme Court precedent and failed to apply it. But even if it were the law, Hunter would fail the test because the costs in this case are not divisible in the way in which they were in the Geary case. Let me comment on the transcripts for a moment, because there are two controlling statutes that we haven't mentioned. One is Revised Code 2301.24, which covers reporters' compensation, and one is 2301.25, which covers transcript costs. And both are very specific in saying that transcripts, regardless of who orders them, transcripts are taxed as costs. Once you recognize that they're taxed as costs, then you get back to Middleburg Heights, and costs are imposed by case rather than by count. With respect to whether we've waived the argument, these arguments by not opposing in the trial court, that argument was not presented in Hunter's primary brief. So we were denied an opportunity in our opposing brief to respond to it. It was raised.
Mr. Axelrod, you are at your time now.
Thank you, Your Honor. I ask that the court affirm the decision of the court below.
Thank you. Mr. Shurkin, rebuttal?
You're muted.
Am I still muted?
Oh, we can hear you.
Okay. I'm not real good at the computer, but at any rate, I do believe that the costs can be allocated. They can be figured out, because the charge that she was convicted of was really separate and apart of anything that really went on with the conducting of court activities. And it was really a very isolated situation. It was an allegation that she had requested a report of an investigation of her brother, who was a corrections guard at the juvenile detention center. And that only involved a very small portion of what took place in the entire trial. As again, I indicate, I don't think it involved more than 4 or 5 witnesses, and probably a half a morning of testimony is all that was really involved in that case. And you could go and parcel that out and take those witnesses out of the cost of the witness fees, as well as taking it from the cost of the total cost of the entire transcripts. In relation to what the Ohio Supreme Court has done or not done, the statute specifically does allow for the trial court to have discretion. Yes, it's mandatory that costs be assessed and calculated and charged, but certainly the language that provides in 2947 31C that the court retains jurisdiction to waive, suspend, or modify the payment of the cost of prosecution, including any cost under section 2947 23(1). It at the time of sentencing or any time thereafter. So it is something that is contemplated, that there's a certain amount of equity to be considered. I don't believe in any case where I've ever gone on an appeal and I've won on the appeal that I've been able to go back to the trial court and say I'm entitled back to the cost of the transcript that I paid for it already. And I think that simply doesn't happen. And I think here the appropriate resolution of this matter is to give the trial court the opportunity to have a hearing and let us get it remanded back to the trial court, let them have a first crack at going through the cost statement. And the other part is that, again, I raised, this court has held in the past that issues that are not raised below are waived in the Court of Appeals. The state took the position not to respond, and they didn't respond at all to any of the arguments. In theory, they should not have even been permitted to respond to our briefs, because the issues that were raised in the trial court, they did not raise at that time, and they're raising it for the first time here. So, our claimant saying in reply, we couldn't anticipate what they might come in and whether they would have filed any response to this appeal. I would urge this court, contrary to what was requested in the briefs, that the court, do a recalculation of the cost. I request that the court, and not simply just take on a pro rata basis, that would be fine, but in the alternative, to remand it back to the trial court to make that initial determination. And thank you.
Thank you, Mr. Strickland. Thank you, gentlemen, for your arguments this morning. The case will be submitted and we'll get out a timely written decision. We hope you both have a great day.
Thank you.